So it's very good to be here today, and I'd like to thank the organisers for including UNHCR in this event on this particularly important topic given the current context and the plans for reform of the Common European Asylum System. I'm going to run through, in general, three of the principal concepts in relation to safe country concepts and some of UNHCR's key concerns in terms of how these concepts should operate in practice. On the title of the event, I think, or the topic that I'm speaking on, all concepts are safe until they're applied. So if the question is, are the safe concepts safe? Yes, the concepts are safe, provided that they are utilised in a way that takes full account of all of the safeguards that are required, and they're properly monitored in the manner in which they are used. Just referring to the communication from the Commission of the 6th of April, there were some proposed amendments for the reform of the Common European Asylum System, which I'm sure many of you are very familiar with. And the aim is to achieve a greater convergence in EU asylum systems and more equal treatment across different countries, and to reduce undue pull factors. And we can see in these different instruments a primary place for the safe country concept, both in the Dublin regulation and in other elements that are looked at to be recast. These changes envisage changes to the common approach to safe country mechanisms, both for safe country of origin and safe third country concepts. And some of the proposed changes would remove Member States' discretion in using these mechanisms. So it makes the proper understanding and application of these concepts even more important if discretion is removed in relation to using them. Just a couple of words in terms of three of the two concepts that I'm going to be speaking about. The first, safe country of origin. In our view at UNHCR, a country can be considered a safe country of origin, meaning a safe country for a person who is from there to be returned to, insofar as it can be shown that there is generally and consistently no persecution, no torture or inhuman or degrading treatment or punishment, and no threat by reason of indiscriminate violence in situations of international or internal armed conflict. So that is what the concept of safe country of origin as it applies to people coming from that country involves. The next concept then is first country of asylum. And the first country of asylum concept is applied in cases where a person has already in a previous state found international protection that is once again accessible and effective for the individual concerned. For those of you who are following closely the EU-Turkey statement, originally that was one of the ideas, was that the inadmissibility procedure would be used in relation to Syrians on the basis of the first country concept for those who had already availed of temporary protection in Turkey. But as we've seen in practice to date, so far this concept has not been utilised by the Greek authorities. They have focused solely on the safe third country concept, which is to be applied in cases where a person could, in a previous state, have applied for international protection, but they did not do so, or where protection was sought but was not determined. The application of the safe third country concept requires an individual assessment of whether the previous state will readmit the person, grant the person access to a fair and efficient procedure for the determination of his or her protection needs, permit the person to remain, and accord the person standards of treatment commensurate with the 1951 Convention and international human rights standards, including protection from refoulement. There should also be a meaningful link or connection that would make it reasonable for any applicant to seek asylum in that state. Mere transit through a third country generally does not constitute a meaningful link. And where the person entitled to protection, a right of legal stay and timely durable solution are also required. And again, in the context of what's happening under the Greece-Turkey statement, the safe third country concept has been applied in the inadmissibility procedure in Greece. And to date, we've seen just over 200 or so cases determined to be inadmissible through using the safe third country concept. Of those, there have been 72 appeals against those decisions, and at the appeals committees in Greece, 70 of those appeals resulted in an overturn of the first instance decision. So only in 2 appeals so far has the appeal committee upheld the original finding that the case could be determined to be inadmissible on the safe third country concept. So what does UNHCR think about these concepts? Well, first of all, we acknowledge the need for member states to employ a variety of tools to deal with mixed arrivals, mixed flows. We have a more general statement out on a 10-point action plan in relation to mixed flows, where you have people arriving in a country, some of whom may likely be in need of protection, others of whom may likely not be in need of protection. And there need to be tools that can enable states to manage those processes in an efficient way. There is a real challenge where states don't have a comprehensive immigration system. There are some member states where if a person arrives in a state irregularly, the sole pathway for them to try and regularise their status is an asylum procedure. So this is a problematic thing, and we constantly advocate for states to have both a protection procedure but also to have migration legal pathways and other ways to regularise irregular cases. The real question is how these concepts can be applied. Starting with the safe countries of origin, the assessment and designation of a country as safe needs to be based on reliable, objective and up-to-date information from a range of credible sources. The assessment needs to consider the legal situation, the general political circumstances, as well as respect for human rights and the rule of law, both in law and in practice. Relevant indicators in this regard are the country's record in ensuring consistent protection for its citizens against persecution and other human rights violations, and its accessibility to independent national or international human rights bodies. The sources used need to be independent and reliable and would generally include up-to-date information from EU member states, the European Asylum Support Office, or EASO, the Council of Europe, and UNHCR. And these bodies are indeed listed in Article 37.3 of the recast EU Asylum Procedures Directive. Any system for designating a country as a safe country of origin should also allow for a regular review of that designation, and that's also provided for in the APD article I just mentioned. Clear benchmarks and criteria need to be defined that would trigger and inform any review of a designation of safety. Both gradual and sudden changes in the country should also be taken into account and allow for suspending or removing a country from a list of safe countries of origin. It's important to keep in mind that a designation of a country of origin as safe creates but a general presumption of safety. It may not be safe for everyone. Despite the designation of a country as safe, it may be that the country isn't safe for particular profiles. So the concept must be applied on an individual basis, and it's the responsibility of the decision maker to determine that the country is safe for the individual in that specific case. And in doing so, they must rely on the type of information I just listed previously, and an opportunity must be given to an applicant to effectively rebut the presumption through a personal interview, receiving legal assistance, and access to an effective remedy. So it's clear that a claim cannot be rejected on the basis of safe country of origin designation alone. In terms of the practice in relation to these things, it's really important in organisations not to allow a culture to build up around designations of safety. So it's important to continue to do training and other tools to make sure that decision makers don't fall into the trap of failing to grant each applicant an effective opportunity to rebut presumptions. A key issue in relation to the concepts as well are the specific situation of persons from minority groups and others at risk. People from particular groups who may be at a greater risk of something bad happening on return, their particular circumstances must be taken into account when the concepts of safety are applied. And we have recommended that a reference to the situation of minority groups and others at risk should be embedded within the EU rules relating to safe country of origin concepts. Moving on to the elements that need to be in place for a country to be considered as a first country of asylum, here we have some different elements. In particular, the assessment of whether a third country constitutes a first country of asylum, again, requires an individual assessment, and the assessment includes determining that the person concerned will not be returned to risk of persecution or serious harm in breach of the principle of non-refoulement. To determine whether they would have sufficient protection available in the third country, Member States may but are not obliged to apply criteria that are set out in Article 38(1) of the APD. So the safeguards that apply for a safe third country are higher than the safeguards that apply for a first country of asylum. And one would presume that the reason for that is for a first country of asylum, the person has already accessed and been granted protection in that other country. So the safeguards that are set out in the EU rules are slightly less. The APD does not define what sufficient protection in the first country of asylum means. However, from a UNHCR point of view, we assume that the directive would need to respect fundamental rights, including the right to asylum under Article 18 of the Charter of Fundamental Rights. And clearly, the core safeguards would include that sufficient protection goes beyond just refoulement. It would also include that access to protection is effective and available in practice, and that it will be clear that the person who has enjoyed asylum in a previous state would be able to re-avail him or herself of that protection. As you may also have seen in advance of the conclusion and later the implementation of the EU-Turkey statement, there was a lot of changes that took place both in the Turkish legislation and in the Greek legislation. In the situation in Turkey, there was some reassurances also given by the Turkish authorities that any Syrian national who had previously availed of temporary protection in Turkey would be able to re-avail or reacquire that on return to Turkey. Previously, the situation had been that the law did not enable somebody to re-avail. An amendment was made in order to make that possible in practice. Given that to date, not a single Syrian has been returned to Turkey under the EU-Turkey statement, in terms of the inadmissibility procedure, we have yet to see whether this re-availment would happen as smoothly as is envisaged in the assurances that have been provided by the diplomats and the legal provisions. So finally, the safe third country concept, again, requires a close individual assessment of whether the previous state will readmit the person, grant the person access to fair and efficient procedure for the determination of their needs, permit the person to remain, and accord the person standards of treatment commensurate with the 1951 Convention and international human rights standards, including protection from refoulement. Where the person is entitled to protection, a legal right of stay and a timely durable solution are also required. When a state is considering applying the safe third country concept, the asylum seeker must have an opportunity to be heard, to rebut the presumption that they will be protected if they are returned in the previous state, and they must be able to appeal the inadmissibility decision before a court or tribunal, and they have a right to remain pending the outcome of an appeal. Suspensive effect is automatic in case of an appeal against a decision based on the safe third country concept under Article 38 of the APD. Interestingly, for the application of the first country concept, the appeal is not suspensive. You have to apply for the court in the first instance to ask the court to apply suspensive effect. However, under the APD, Article 38, an appeal is suspensive for an appeal against a ruling that a country is safe for you on the basis of a safe third country concept. Coming back to what's currently happening in Greece, of the two cases that were upheld on appeal, one of those I mentioned has been appealed to the Greek Administrative Court, and our understanding is that in the initial phase, that person is seeking a ruling that suspensive effect will apply. So it's a little bit unclear why they're having to take that step when the APD already requires that such an appeal should have suspensive effect. We understand that's ongoing, and a decision should issue from the Greek Administrative Court on Friday. It was originally due this Monday, but I hear it's been put back to Friday. In addition, in relation to the application of the safe third country concept, the APD introduces the requirement of a sufficient connection to the third country. So in our view, transit alone is not sufficient for a sufficient connection or a meaningful link, unless there's a formal agreement between the countries concerned and clarity that the protection between those two countries is on a parity basis. Transit, we take the view, is often the result of accidental circumstances and does not necessarily imply the existence of any meaningful link or connection. Neither does a simple entitlement to entry without actual presence constitute a link. In terms of applicants with specific procedural needs, there is a provision in Article 24 of the APD that requires that Member States must provide applicants identified as in need of special procedures guarantees that adequate supports will be provided throughout the asylum procedure. And these adequate supports are not fleshed out in the APD, but the recital to the APD sets out that such persons should have sufficient time, that they should have sufficient support extended to them in terms of these procedures. And we take the view in UNHCR that where these safe country concepts are being applied, they are often applied in accelerated procedures or accelerated border procedures. Reading into the recital, we would take the view that people with specific procedural needs who find it difficult to cope in these kind of procedures should not be put through these accelerated procedures, but should go through the regular in-merits procedure so that the appropriate supports can be extended to them. Again, in terms of the EU-Turkey statement, you may also have seen that the Greek law was revised. Prior to the EU-Turkey statement, the Greek law had not fully transposed the inadmissibility provisions and safe concept provisions of the Asylum Procedures Directive, so it was updated to reflect those provisions. And one of the welcome things that happened during that recent legislative amendment was that vulnerable applicants have been excluded from the scope of the inadmissibility procedure in Greece at present. So if you look at the case processing rates, a significant number of cases in Greece are not put through the inadmissibility procedure because people have certain vulnerabilities or are unaccompanied children, or there are health issues, or there are people who are previously victims of torture or victims of trafficking. We see a significant number of those cases that are not going through the inadmissibility procedure. And that's something that we welcome in order for those cases to be dealt with appropriately. One of the key issues in terms of the operation of these concepts is the use of good, rigorous, independent, reliable country information. So underlying all of these concepts are the idea that before designating a country as a safe country of origin, as a first country of asylum, or a safe third country, that those decisions will be based on robust, good, credible, reliable information. And what we see at the moment in the current context, perhaps because of the multiplicity of conflicts worldwide, perhaps because of the nature of the world that we live in, we have some conflicts that are quite well documented. We have others that are not well documented at all. We also have other situations which are highly political in nature, where getting good country of origin information is very difficult, or where producing good country of origin information can be politically quite a difficult thing to do. So I think what is really important is that if we are to move forward in a new common European asylum space that relies very heavily on safe country concepts, we need to make sure that we have the institutions in place that can deliver and provide up-to-date, reliable information on these countries and on the individual circumstances of people in those countries so that correct decisions can be made by member states. I think this is in the interests of member states, it's in the interests of the institutions, and it's certainly in the interests of persons of concern to UNHCR. One of the key dynamics in relation to country of origin information to underpin these concepts is the need, I guess, to separate out two things. One is an assessment of the situation in a country, which should be done by people with expertise who are independent and who can produce reliable information. Then secondly comes the assessment as to whether the facts that are set out in those country reports indicate whether a country should be a safe third country, so designated by a member state. And the risk is that if you start off with the task of deciding whether a country is a safe third country or not, whoever you are as the researcher, there's always going to be an element of bias in relation to that investigation that you're doing. So it would be a useful thing to separate out those two tasks. There is an enhanced role for the European Asylum Support Office envisaged in the new European Union Asylum Agency proposal, which was recently released, and I'm sure which many of you are looking at. So there's an increased role for the European Asylum Support Office to perhaps do further work in this domain. The European Asylum Support Office has already been requested to assist in relation to the safe countries of origin and to provide reports in relation to the current countries that are being proposed for a listing in relation to safe countries of origin. In addition, what would be ideal is, given that we're all working towards a more coherent common European asylum system, that there would be coherence across the EU member states in relation to their listings. We did a study in recent years looking at which member states in the European Union list which countries as safe countries of origin or safe third countries, and there's great diversion across member states in relation to this. If the plan is to have a more comprehensive view, then I think it would be useful to have good information underpinning those decisions, but for member states also to take a coherent approach, and also for member states to take a harmonised approach to the review of information. If information indicates a deteriorating human rights situation in a country, in principle, all EU member states should be participating in the same review at the same time, so we don't have a situation where some member states are relying on information that's older than others. In conclusion, I'd like to say that international refugee law and European asylum law foresee the possibility of returning persons seeking and/or in need of international protection to a safe third country or a first country of asylum, and you know the laws foresee this, and we're all aware of this. However, what is crucially important is the safeguards that are already set out in the Asylum Procedures Directive are implemented. We would like to see those safeguards that are quite comprehensively listed for the safe third country concepts applying more broadly for all concepts. And also it would be useful to have a harmonised approach to ensure that vulnerable applicants, unaccompanied minors and others are not included within the application of those concepts. I think I'll leave it there to allow for any questions. Thank you.